All right, good afternoon. It's October 16th, 2016, and today I'm going to talk about um, Medco-14 and C84, which are two key documents in order to get temporary total compensation. So, your physician record, the person who's taking care of you for your workers' comp claim, is going to fill out the Medco-14, and you, the injured worker, are going to fill out a C84, which is a request for temporary total compensation. So, if we don't have either of these documents, you're not going to get TT, and there's a few things I want to go over that can catch you up, can trip you up, and prevent you from getting TT, or delaying the receipt of TT, or if you're receiving TT, it could stop your TT, your temporary total disability compensation. So for the first thing I'm going to go over, and I think the way I'm going to do this is I'm going to talk about it, and then on the video I'm going to essentially just throw up the video or the document and highlight what I'm talking about as I do so. But the first thing I'll talk about is the Medco-14, which again, your physician record, your doctor, your BWC doctor will fill out. And so you have your injured worker's name, your claim number, which is your BWC claim number, and then date of injury, date of last appointment exam, date of this appointment exam, and date of next appointment exam. Pretty basic stuff. Your doctor, if they've never filled one of these out before, in section 1 they'll probably put I've never completed a Medco-14 before. Then the next thing you go to 2, and please indicate, well, it's, have you reviewed the description of the injured worker's job? And they'll probably say yes. And if yes, please include who provided the description. It'll be the injured worker, or employer, or the BWC, or the MCO. Now we get to the meat of the thing. The important part is in 3A. Does the injured worker have any physical or health restrictions related to this allowed conditions of this claim? Likely, if you're going to the doctor, they're going to say yes. If yes, are the restrictions permanent or temporary? Likely they're going to say temporary. Then you're going to go to section 3B, and this is, again, an important section. If there are restrictions, can the injured worker return to the full duties of his or her job held on the date of injury? Yes or no? They might say yes, or they might say no. Likely they're going to say no. You can't return to the full duties. And if no, now this is key, this is going to determine this first date. Please, when injured, could not do the job held on the date of the injury for this period of restricted duty. So for this first date, for many injured workers, not all, but for many, this date is going to be the date of injury. So let's say you got injured on April, 3rd, 2016. So this date will probably be April 3rd, 2016. And then please estimate when the injured worker should be able to return to the job held on the date for this restricted period of duty. So this is where, depending on which kind of doctor you go to and how they like to manage your claim, there's some doctors who will put this date out, a few weeks, and it'll correspond to the next visit date. And so in this way, your doctors can, in a sense, require you to continue to return and visit them more often than others. Some doctors might put this out for a few months, 2 or 3 months, depending on how injured you are, depending on the extent of your injuries. So if you have like a pretty serious back injury, and they're not going to see you again for a few months, they might put it out 2 or 3 months. So let's say this doctor puts you out for 2 or 3 months ahead. So you'd say 4/3/2016 is when you were injured. You couldn't do the job held on the day of this injury for this period of restricted duty. So that's the first number. And then if they put you out 2 or 3 months ahead, it'd be 6/3/2016. It could be 7/3/2016. Point is, you want to keep track of that second number. You want to be aware of that second number, because when you're getting TT until that number. So if your doctor certifies you if he says you're not able to do the job on you're not able to do it until this date, so they'll estimate, again, please estimate when the injured worker should be able to return to the job held on the date of injury for this period of restricted duty. And there's, again, section 3B, they'll throw out a prospective number, and when you receive TT, you'll get TT until this prospective number. Now, if you don't keep track of this number, or your doctor doesn't, or your attorney doesn't, and it's then what would happen is, if you're getting TT and you're not certified beyond that date, if you haven't gone back to the doctor, or you've gone back to the doctor and for whatever reason they haven't recertified you, then after that date you are not entitled to TT. And so the BWC will put a hold on the TT, or they'll stop it, and it could be a pain, because it could require that you start up the whole process again requesting TT. The BWC will have to go do a physician review to determine whether you're entitled to TT. So you want to be aware of that number, these two numbers. That second number, you always want to be aware of when's that date coming up, because you want to get a new Medco before that date runs up. Again, if you wait, if you forget about it and it runs up, it could cause problems. So that second number, be cognizant of it, and get recertification. Now, if you go back to work, who cares? It's not relevant. But if you're still on TT, you're still injured, you're still going through treatment, you're still not able to go back to work, you want to continue to get certified by your doctor. So then you have 3C. Please, it says, if the injured worker is not released to the former position of employment but may return to available and appropriate work with restrictions, please indicate the possible return to work date. So this might be the situation where you could be temporarily totally disabled, where you can't do any work, or you could be temporarily and totally disabled, but you could return to work with restrictions. So you may have work restrictions that don't completely remove you from the workplace. And so in this section 3C, this is all about restrictions. So if you're so injured that there's no restriction that's going to allow you to go back to work, then your doctor is not going to necessarily fill this out. However, if you are able to go back to work, your doctor is going to see all these. It says activity, bend, squat, kneel, twist, turn, climb. It says never, occasionally, frequently, continuously. And it says reach above the shoulder type. And then it has this lifting and carrying of 0 to 10, 11 to 20. So your doctor is going to, let's say you injured your shoulder, okay? So your doctor might say, you can occasionally lift 0 to 10 pounds, but you can never lift 11 to 20. And then essentially, if you can't lift 11 to 20, then you're not going to be able to lift anything beyond that. Likewise, with these pushing and pulling, maybe you could do up to 25 pounds occasionally, or your doctor might tweak that so it's 0 to 10 pounds. Your doctor will know what you're capable of, and then they'll put it in there. How many total hours can the injured worker work? If there's some time limitation, this is where it's going to be. So it says, you can work 5 days a week, 8 hours a day, right? And then you might have restrictions on how many hours you could sit, walk, stand. Your doctors are going to tweak that to your injury. Now, if you see in 3C these lines, which kind of indicate, a place where your doctor could put additional information, some employers, unless something's pedantically written down there, like it specifically states the injured worker can't do task X, and let's say task X is putting cans in a box. For whatever reason, you can't put cans in the box, and that's something that you've talked to the doctor and you're like, hey, I went back to work and they're having me put cans in the box, and I tried to do it because of my work injury. I can't put the cans in the box. There might be something else I can do at the job, but the cans in the box thing I can't do. And so some employers might be like, well, we're looking at the restrictions and it doesn't say anything about not putting cans in boxes, so you got to be able to do this cans in the box. So at that point, you'd have to say, doctor, you have to explicitly put, injured worker can't put cans in the box. And then you'd have to give this to your employer, and your employer would be like, okay, you can't put cans in boxes, so we're not going to have you do that. Sometimes employers can be, recalcitrant about following through. So at that point, sometimes it helps to call your doctor and say, hey, doctor, you're gonna have to explain these restrictions to the employer. They don't understand, even though it's explicitly written there. And so your doctor would say, hey, she can't do this because, her hand, the way she injured her hand or her shoulder, by putting cans in boxes, it exacerbates her injuries. It's detrimental to her, healing process. So no cans in boxes. Sometimes these things come up. Sometimes employers are, very respectful of these restrictions. Sometimes you'll have employers that like to play games, and when that happens, you get your attorney and your doctor involved. Okay, so this is the first page of this document. Again, the important part is section 3B and these two numbers, and you always got to be cognizant of that second number. Okay, it's super important. So then we go to the second page, and then this is where your doctor has to put the allowed conditions in the claim. So, and is the condition prevailing in full duty release, and you'd say yes or no. And it's important that you're being certified for allowed conditions in the claim. So if your doctor, let's say your claim is allowed for a sprain strain of the lumbar, the lower back, and then you've had an MRI that shows herniated disc at L5S1. This is this is in the lower back as well. And often when you get lower back injury, they'll be allowed for a lumbar strain. You'll have an MRI diagnostic of your lower back, and it might show you have a herniated disc or a deteriorated disc or lumbar stenosis. These are all back disc conditions. So they're more serious conditions, but if your claim is only allowed for lumbar sprain strain, you got to put your doctor's got to put lumbar sprain strain. That's what you're being certified. That's what's preventing you from returning to work. If your doctor puts like L5S1, or let's say you have L5S1, and then also for whatever reason you have some knee injury or something that is completely unrelated to your claim. If your doctor puts like whatever this knee injury in there, and they're saying you can't return to work because of that knee injury or the L5S1, that's going to cause you problems. So your doctor is going to put the injuries that are allowed in the claim as that is what's causing you, that's what's preventing you from returning to work. You might have a more serious condition, but until you get those more serious conditions added to the claim, again, the fiction of workers' comp world is the things you are not paid or treated for conditions that are allowed that aren't allowed yet. So you may have a disc condition, but until it's allowed, you're not going to get shots for that disc condition. You're not going to get surgery for that disc condition. For all intents and purposes, it doesn't exist. Okay, and then they might say this clinical findings 5, the injured worker is progressing. I don't know. They'll say this is kind of just a perfunctory thing, as expected, better than expected, slower than expected. They might put some additional stuff. This isn't key. Maximum medical improvement. If you want to get TT and you don't want to be MMI. So if you're MMI, usually it's the injured worker's doctor is not going to be the one who's saying you're MMI, because what MMI means is maximum medical improvement. This is section 6 I'm talking about. What that means is you essentially your injury has reached a treatment plateau. So they've done all the diagnostics, they've done all the type of treatment, they've done everything for that condition. It's not getting better, it's not getting worse, it's at a stable position. So and that's kind of a cause of frustration for a lot of injured workers, because what happens is they're like, I still hurt, I'm not back to my normal self, I still have problems, before this injury I was okay, I could do X, Y, and Z, and now I can't, and how can they say I'm MMI? Well, it doesn't mean that you're necessarily better. It just means that, let's say even if we spend like $1 million, well, you're not going to get better. So we could throw more money on it. It's just not cost. There's a financial weighing of things, and then in the BWC. So it's kind of like, well, even if we throw a bunch of money at this, it's not going to get better. And so you're at a treatment plateau. And so what that means, and that kind of is when you reach MMI, that kind of puts the kibosh on further treatment. They might have, I don't know, sometimes you get chiro and stuff, chiro treatment, additional chiro treatment if you're working. But if you're not, it's kind of means the ending of your claim. So, but in terms of TT, when you're MMI, that means you are not. It basically cuts off the TT. So once you reach MMI, maximum medical improvement, it cuts off TT. You don't get TT anymore, and that's kind of basically saying, hey, you're no longer temporarily totally disabled. This disability has either become permanent, or whatever, or it should be you've reached MMI, you've done all this treatment. There's, all you have is a sprain strain your claim. What are you doing? You should go back to work or whatever. At that point, so if it's reached permanent, it's a serious enough thing. It might be that you will apply for permanent total disability. It might be that you enter in a vocational rehabilitation work program so that you get trained in an area, using your experience, your skill set, and intelligence, to transition in an area that will take in mind your physical limitations because of your work injury. And so, we've had people go into vocational training, have learn how to work on air conditioning units, been trained as, to hotel management. So they may have been in some kind of security situation, and now they're managing hotel. Someone was working might have had some tech experience. They're working like a warehouse job, so they went some vocational rehabilitation training, and they're trained to become technical support type of person, IT type of person. So if you go through and you get paid during the vocational rehabilitation training or period. We'll go on to that in more significant detail at a later point, but regardless, for now, 6, maximum medical improvement. Likely the injured worker doctor is not going to say that you've reached MMI. If they do, that's going to prevent you from getting TT. So then we go on to section 7, again, vocational rehabilitation. This is what I was just talking about. If your doctor is still treating you, if you're kind of in the early stages, or you're still actively treating your work injury, if there's things that your doctor thinks you're just not ready for vocational rehabilitation, they might say no, and they might explain why. Otherwise, they'll just say yes, you would be, it might be a good idea for you to, or you would be able to participate in vocational rehabilitation. So then your doctor, the number 8, your doctor's going to sign, date, etc. So this is Medco-14. This is the 2 parts of, you got your Medco-14, your doctor fills it out, you fill out the C84. I've already gone about 20 minutes on this, so I'm going to put we're going to have another video where we talk about strictly just the C84. But remember, I just think, again, a really important thing is section 3B, there's those 2 dates. That second date, you really got to watch that, because if you and these are the trigger, the danger zones, the things that cause you problems. That second date, if you go over it, if you don't get recertified by that second date, your TT is going to be cut off. And then the section 4A, if your doctor is certifying you, if he's saying you're not able to work because of conditions not allowing the claim, again, that's going to cause problems in your receipt of TT as well. So I think these are 2 of the bigger problem areas. Again, 3B and 4A. so we can talk about that further. One final thing with these work restrictions. So let's say your doctor has released you to work with work restrictions. So the way it works is if you have work restrictions and you're not completely temporarily and totally disabled, what that opens the door to is your employer is going to see this and they're going to, okay, I see the restrictions. Okay, and then what they're going to do is they're going to give you a light duty written job offer. If they give you a light written duty job offer that takes into account the work restrictions indicated in Section 3C of the Medco-14, then you have to, and they honestly take into account the restrictions, then you have to take that, do that job. And if you don't, then that means you're rejecting the written light duty job offer, and then that severs your entitlement to TT. So you're not going to get TT. So you're like, oh, I'm not doing that. Well, then you're not going to get TT. You're not going to get, or and you decide to stay at home. And one, you're not going to get paid at work, but two, you're not going to be entitled temporarily to disability compensation. If you think these restrictions do not accurately reflect your abilities, that's something you're going to need to talk with your doctor and say, hey, doc, I see what you've written here, but honestly, like, I can't do this. So they'll listen to you. They'll take into account the objective findings that they've made. They'll take into account your subjective complaints, and they'll craft it so it accurately reflects what you're able to do. Now, the other thing with the light duty, let's say your doctor releases you to work with, light duty, with work restrictions. So the interesting thing is that, let's say you work at the job and the job fired you, and then your doctor has, so you're fired from your job, but you have work restrictions. So really, you'd be able to go back to work, but you're fired from the job, so you're not going to be able to go back to that job because you're fired, right? So unless you've done something, and we've talked about this in another video, where can be construed as voluntarily abandon the job, like you violate a workplace rule violation, then even if you just have work restrictions, you can't do the job because you've been fired, so you'd be entitled to TT. Now, if you have violated a workplace rule violation, you're not going to be able to receive TT anyway. So if that's the reason why you're fired, you're not going to be able to receive TT. So this is Medco-14s. Again, this is what your doctor fills out. We're going to talk about C84 in another video, and it should be a little bit quicker because the C84 is pretty straightforward, but there's still some things that could catch you up. So anyways, signing off, this is Kip Malek from Malek & Malek, explaining the Medco-14. Hopefully I've made it a bit more clear. If not, again, call your attorney. If you're your attorney, we'll explain to you in excruciating detail. If we're not your attorney, I'm sure your attorney will do so. And if you're, as always, recommend that you get an attorney if your claim, I don't know, I just recommend, if you have a work injury and it's significant enough that you're treating for it with it's beyond, you've went to the ER, you just got patched up. If you're continuing to go to a doctor over and over again, you're going to probably need an attorney. So recommend you get an attorney, whether it's us or another attorney law firm. Otherwise, have a nice day, and hopefully it's helped you.